Okay, now we're recording. Again, good morning, everyone. We're here today in the matter of Lisa Schachtner, CBA 24-011. This is a motion for reconsideration filed by VJ Krieshman. He looks like it was filed on April 17th, 2024. Looks like after his motion for reconsideration was filed, there was opposition motions filed. One by Baltimore County, Ms. Merrick, and one by Ms. McCoy on behalf of Ms. Schachtner. As we all know, we're governed by Rule 12 of the Board of Appeals Rules of Practice and Procedure, and we are here today for a public deliberation on that. So I guess we can get started. Does anybody have anything they want to say about the motion for reconsideration?
I don't think that the arguments advanced for reconsideration fall within Rule 12. I also note that it was an on-the-record appeal and those matters were not raised below. So they're not in the record that was before us, to which we were limited.
I agree.
And on that basis, I would say the motion has to fail.
Mr. Stelmack?
Yes, and I just want to clarify, that this is an issue of, at least in my mind, who's allowed to appeal. And here, the complainant, he is essentially a witness for the county at the hearing for the Animal Hearing Board. And I agree with the county's memorandum that only the county and the person who cited have standing to ask for reconsideration. I think, ideally we would have some sort of motion system to, maybe deal with this issue before it comes to a public hearing on the reconsideration, but we don't really have a system like that. But setting that aside, I do want to say, because it would be, I think we probably all agree that this matter can be disposed of just on the issue of standing. I agree with Ms. Dobkin that a lot of the matters raised by the complainant were not brought up in the hearing below, and therefore we can't hear them. But I think, that and, his overall complaint is understandable because, and I think that goes to the issue of the failure of the Animal Hearing Board to have a fair hearing, because it's not just the person who is the defendant in that hearing that has the potential to be wronged in that situation. The person who's the complainant may have serious issues that they suffered and wants, the assistance of the county to help them to not necessarily even punish the wrongdoer, but just to make sure it doesn't happen again. And that hasn't happened here. And that's through no fault of his. It's not through our fault, it's just, this is the system we have. And I think that that his request, his appeal, obviously he's not an attorney, reveals a misunderstanding of our role in this process, which is not to rehear the facts of the case, which sounds like what he wants us to do is to rehear the facts of the case, and that's not really our role. Our role is to make sure that the process was fair and there was no error. And I think the text of our opinion shows why we had to make the decision that we made. But also, I don't, I hope you don't mind, Mr. Chairman, if I just go off on a little bit of a want to preach a sermon here, but in the course of looking all this over again, it would be foolish not to pretend that the parties are not, in attendance and listening to what we have to say. And I think that one of the things, I think I've been on the board for a year now. And one of the things that I've noticed is that a lot of the things that come before us are, neighbors who are in conflict, and people want a good resolution to the conflict that they have, and sometimes we can't give them that. And then, my feeling is that they're going to advance that conflict through other means, or continue to try to use the county to advance that conflict. And what I want to say is, what I hear over and over again, both at the lower level and before us, is that people need to get along, and they need to figure out a way to live with each other. And I support that, but also I understand that in many cases that is not a situation that the parties find themselves in, where they feel like they can come to a resolution with each other. And what I want to say in this case is, I think that both of the people involved are reasonable people who, truly believe that they're in the right. And I think that they're the kind of people who ultimately could get along if they want to make the effort to do that. And I think that it's not enough just to say, get along with each other. Both people have to want to make a reconciliation, and they have to want to decide to be neighbors. And even if they don't like each other, both of them are going to still be living next to each other. One of them is still going to have, the dog or a dog, and this issue is going to come up again. And I'm not a huge proponent of like any sort of dispute resolution mechanisms. I've found they're not that great for the most part, but I have found that Baltimore County has a good community mediation program where you can ask for help, and you can sit down with each other, and you can try to resolve problems with each other. And I would like to suggest that in this case, because I think that there's a good opportunity for the people involved in this case to live with each other and to move on with their lives past this. So that's all I have, Mr. Chairman.
All right, thank you, Mr. Stelmack. So I think, just going back here, I think we're all in agreement that I guess we should make sure we're all clear. Do we all agree that Mr. Krieshman doesn't have standing to file this motion? And do we agree on that? Okay. And even if he did have standing, we also agree that the motion fails regardless.
On the basis of Rule 12.
Correct.
And the limitations of the record below.
Okay, we all agree on that.
I mean, side issue that our determination was based on due process issues primarily, and also, and so I think that's part of it, is the facts were not well developed, and so we had no choice but to dismiss it or to, so.
Yep, agreed. Okay. Unless anybody has anything else, I guess we'll go off the record. All right.